Swayam Prabha. Digital India. Educated India.
I would like to thank AICTE for allowing me to give a talk on Introduction to Intellectual Property. This is a very basic presentation that I make mainly for students. My name is Dr. Malti Lakshmi Kumaran. I'm an executive director at the law firm Lakshmi Kumaran Sridharan. I've been a scientist for 25 years and then I moved into patent law. I'm a patent agent and I do a lot of teaching, plus I also practice patent law. I try to get patents for my clients, applicants, and so on. So here, without any waste of time, we go and talk about intellectual property. If you look at it, there are different forms of intellectual property. You may have heard about property. You can own a house, you can own a car, you can own a watch, and so on. But this type of intellectual property is dependent based on your intellectual creations. And so the different forms of intellectual property, it can be patents, it can be designs, it can be trademark, copyright, plant variety, or even GI, or trade secrets also, or GI. You may have a product. Let's say I have a phone, and in the phone, we have different types of intellectual property. One of the simplest one is, you look at any child and they'll say, give me an Apple phone, give me a Samsung phone, give me this phone. So they know by just looking at the trademark, and here you can see an Apple trademark. The minute they see an apple, they don't confuse with the apple that they eat. They look at the logo. Or if it is a Mercedes-Benz, or if it is a Suzuki car, or it is a Surf, looking at it, or even like a Coca-Cola or a Pepsi, even a child who cannot speak can identify what that product is based on the logo. That logo is what we call as a trademark. And trademark is a very important intellectual property. It talks about the brand value of that. So you have different types of trademarks that you can have, which I will be talking about it. So the trademark here is the Apple logo, and you immediately know that it is an Apple Watch. Next comes the design. Design is also an intellectual property. It actually tells you how the phone, what it looks like, how it is. It's a rectangle. You also have certain app features on it, but it's basically the outline. So if I say I'm wearing a spectacles, the design of the spectacles can be a design protection, or I buy nice jewelry. The jewelry can also be a design protection. So also, if I wear a nice sari and I want to show my sari, and that can also be a design protection. So design is also an intellectual property, and the minute it only depends on the aesthetic value, which I will be talking later on. Then finally, this phone also has patents. Now, patents are intellectual properties, but it is for how it works. What is the invention in it? Okay, so that is where I can have a chip, I can have a software, I can have an application. All these are protected by a patent. But we also have copyright protection. So what do I mean by copyright protection? It is on how it looks. Copyright is also an intellectual property, and it's an expression of an idea. Like in the phone, you have a software or something that can also be copyrighted. A code can be copyrighted. I also look at how an expression of an idea can relate to a painting or a writing. So let us take an M.F. Hussain painting. It's the expression of his idea, how he paints it. That is a copyrighted thing. Just like I said about lyrics, about books, about what you write can all be copyrighted. So copyright is with an expression of an idea. It can go to software, it can go to drawings, it can go to paintings, it can go to lyrics, it can go to movies, it can go to music, it can also go to paintings and so on. So that's a whole area. But now I would like to know, what is the term of the intellectual property? Like you own a house, you can keep it forever. but there are different times that you can have a term. Like if it is an invention and it is a patent, then the term of the patent protection is 20 years. If it is like a copyright, which is an expression of an idea, it is 50 years plus. And if it's a design patent that I get for an ornamental design, like I talked about it, it is 10 years. And if it is a trademark, which is for an identity, for a brand, it is perpetual. Know-how, which is a trade secret, can be also perpetual. So these are time of term that you get for the term of the different types of intellectual property. I would next go to trademark protection. What do I mean by trademark protection? A trademark is a mark which is capable of being represented graphically. It can be like a design, it can be in different types. It should be able to distinguish the goods and services from others. So it need not be only on the logo, it can be the music sign, it can be the smell of a perfume. All these can be trademark protected. I'll just give you some examples of the trademark. And so it can be a word, like I said, Apple or a Samsung, just the word, Coca-Cola, Pepsi, these are words, or surf. Words, the words itself can be a trademark protected, and therefore that can be one. It can also be a logo, like I said, a Samsung logo, an Apple logo. The logos, even without the word, like in Apple, there is no word, but that can also be trademark protected. So you know what you can have for Audi. This is a JW Marriott type of logos. So logos can also be trademark protected, including words, logos. Sometimes it can be just letter, like W, okay, or West Side, or GE. These are just words. They don't even say something. These can be also trademark protected. What are the other types of examples that you have? You have a ticket like a Wrangler or Levi's, or just a small little label. These can also be trademark protected. Or it can be names of celebrities like Mahendra Singh Dhoni, Sachin Tendulkar, Amitabh Bachchan, Baba Ramdev. These are celebrities, and the celebrity names can also be trademark protected. Or it can be signatures of Amitabh Bachchan and so on. So even signatures can be trademark protected. What are the other trademark examples that I can give you? It depends on the packaging. Like you have the Ferrero Rocher chocolates. It's like a cup with a wrapper on it, which is brown chocolates inside, but you have a golden wrapper on it. You have a brown cup with a wrapper which is golden color. Just looking at that wrapper and the chocolate cupcake, you will know that the packaging can also be trademark protected. Or it can be a combination of colors, like Cadbury's. You have a purple colors with white written on it. Then you get that color and you say, that's a Cadbury's chocolate. Or it can be like in Colgate, you have a red background with white letters. So immediately you know that these are trademark protected. I would also like to shift into some others where there can be sometimes, like what I said about Ferrero, it can also be a design, but we like to take it like a trademark. I'd also like to shift my gears now and talk about industrial design examples. So as I said, we've looked at trademark, but now I'd like to look at industrial design. What are industrial designs? They are the way they look. As I told you, on a patent, it is the invention. In the trademark, it is how you can actually present it, like Coca-Cola or Samsung or Apple. But in a design, it is how the design looks. Is it new? Is it an original design? So it covers the shape and the configuration, the pattern, the ornament, the composition of the lines, including the colors. These are things. So if you look at my frame, that's a design. Or you look at the jewelry, that can be a design. So it's basically how the eye looks at it, what you look at from the eyes. And you decide, that's a good design. Or I'm going and having a Kanchipuram sari or Ikat sari. Those designs can also be protected. But there are different classes. In trademark also you have different classes. In design also we have different classes in which we can protect our designs. Can I go to the next slide, and then we will be able to see you some different examples. Like I look at a Toblerone. Toblerone is like a triangular shape, And just the triangular shape is a design example. The minute you see the Toblerone is a trademark name for it, the design, the triangle shape of the chocolate or the triangle of the outside packaging can all be a design, and even the Toblerone is a trademark. Or there are different examples of how a chocolate can come in the form of a cup, or it can come in the form of a oval shape, which is a Kinder type of chocolates. Another very important example are bottles. So it can be a liquor bottle, a wine bottle, or a champagne bottle, the shape of the bottle, or it could be a perfume bottles. They take a lot of time to design the bottle because the design is very appealing to the eye. It does not matter what is inside the bottle. It is the shape of the bottle, the feel of the bottle, how it looks, how I see it, and I can design. So the design protection is on the aesthetics, how it is designed. So I take a bottle and say, that's a very good design, and you can actually protect the design. You can also protect the lid if it is in the form of a design. As I've shown you different types of bottles, or you look at a Coca-Cola bottle or a Bisleri bottle, the shape of the bottle, the outer lining of the bottle can all be protected under the design portfolio. What I would like to now shift is to give you some examples of a patent, which is very important for students who are in the STEM area, that is science area, the technology area. Because as I talk to you about trademark, copyright, or designs, the patent is based only a lot on the inventions that you do. How do you come up with innovations? What type of lab experiments you do? How do I protect a molecule? How do I protect a technology? Is all protected under the intellectual property called patents. But in patents, we have a life cycle. Like I said, in trademark, it can be perpetual. In design, the term is 10 years, but for patent, the term is 20 years. So you need to create your wealth within these 20 years. So the first part of a patent is I need to create. I need to do R&D and to create an innovation, which happens mainly in the lab, mainly in a company where there are researchers, scientists who will create in an R&D department or in a science department. Like CSIR has many departments, has many institutions, and they do a lot of R&D. It could also be IITs, universities, who are all innovating in their departments, and this is called as research and development. So the first step is creation. You have an idea, you do a research on it, you develop it, and then you have created intellectual property in the form of a patent. But how do I do it? If you don't protect it, you do not get protection. If you just publish it, you will not get protection. So you need to protect it by asking for an intellectual property in the form of a patent. So the second part is you create. The second part is you protect it by patents, which is called as intellectual property. Okay, I've created a patent, but now I need to commercialize. If I commercialize, I can get to the market, and once I commercialize, I can make revenue from that. It's not that all patents do commercialize, but I can keep improving my patent till I've got the best model or the best prototype which I can sell in the market. So it can be drugs, it can be technology, it can be apps on an iPhone, and so on. So the third part is the marketing part, which then leads to revenue. Now once I get revenue from that, I can put that money back into R&D. So if you look at large companies, they create a lot of wealth. They create revenue, they get revenue from their commercialization, but they need to put it back or plow it back into R&D and create. So this is what I call as an IPR life cycle. For a patents, it can be used in other things as well. And so why do we do it? Why do we go into all these things? The intellectual property has certain characteristics. It's an exclusive right. So if I have a trademark or I have a patent, it is mine and only mine. I have an exclusive right because it is created. This creation is because of my intellect. Intellect, either in the form of trademark, either in the form of copyright, or in the form of designs, or it can be in the form of a patent protection, where patents are mainly with innovations. Now, this can be a negative right or a positive right. What do I mean by that? In patents, it can be a negative right. What do I mean by that? That is, I've created a product, but that doesn't mean I can actually sell in the market. I need to see that I'm not infringing others' rights and they cannot use my invention. So exclusivity stays with me, but I have to be careful before I commercialize. But let us look at a trademark or a copyright or a drawing. It is mine and mine alone, and it's a positive right. So then you need to see, depending on what type of intellectual property, that whether it's a negative right or a positive right. Now, this type of property, which I call as intellectual property, can also be bought, it can be sold, it can be licensed, it can be inherited as well. So this is like any other property, and I can create wealth out of it. I earn revenue from it, and I can stop others from using my intellectual property, and that's how I create an exclusivity too. However, intellectual property is a legal right. What do I mean? It has a certain jurisdiction. So when I have created and I have protected a patent in India, then the jurisdiction is only India. So if I have a trademark in India, then the jurisdiction is India. So basically, but like books, if it goes all over the world, copyright is something that I don't need to register. But for a patent, I have to go to the patent office, I have to apply for a patent and get it granted. So that is where you need is a legal instrument, and it depends on which countries you've applied for it and the countries that you get for a protection. I'd like to also switch gears here and talk about patents. How is it different from other forms of intellectual property? A patent is for an invention. It is for an invention. It is for an idea, but I need to actually bring it to practice, what we call as reduction to practice. So it's just an idea, you can file it as a copyright, but an idea which will actually work, it is capable of industrial application, is required. So there are three criteria for a patent. One, it has to be novel. Two, it has to be inventive. And third, it must be capable of industrial application. So people have an idea. When they have a problem and they want to solve the problem, then we say, oh, you've got a good idea, you can solve this problem by a patent, by your invention, and then you go and protect it. I'm just going to give some ideas, like a rocking chair, or I want to transfer the voice signal into a small bandwidth. These are all different types of invention, and it can be in the pharma field, it can be in chemistry field, it can be in several other fields as well. So as I told you, there are three criteria for getting your patent. It should be novel. What does a novel mean? It should not have been published, or somebody else should not have done that same invention. So a publication can destroy the novelty of your invention. So you need to look for it. A patent which is published or an article which is published can destroy the novelty of your thing. So invention has to be novel. That is, it should not have come into the public domain. If you talk about it, you put it on the internet, you can lose the novelty for your invention. We always tell people, don't publish your articles, don't publish your inventions, file a patent and then publish it. In that way, you're able to protect the novelty of your invention. The other is inventive step. Inventive step is a technical advancement as compared to what is existing in the knowledge, or it should have economic significance, or it can have both. That is, my invention can have technical advancement and it can be economically significant. What I mean by economic significance, it is cheaper to make, it is faster, it's easier to do it. Those are the economic significance. And the third, as I told you, is capable of industrial applications. A lot of the people think that inventions have to be Nobel Prize winning inventions, otherwise we cannot patent it, we cannot protect it by patents. However, there are very simple inventions which can be patented, like a paper clip, a straw, or it can be a post-it as well. So the post-it, they had an adhesive which was not sticking at all, it would come off. So they used that adhesive which didn't work properly to make Post-it, and 3M makes huge money by Post-it. We all use it, but this was actually a failed instrument which they could then come up with this idea of a Post-it. So there are many types of inventions that you can actually protect. It doesn't have to be a Nobel Prize winning or something out of the world, but simple innovations. I'm just going to come to an example of a chair. We all know a chair. A chair will have a seat, a chair will have a backrest, chair will have 4 legs. So if you look at the example 1, that's a typical chair. Let's for an example come up and say that somebody had already protected the invention. I'm not talking about the designs now, I'm talking about a patent protection for a chair. It's a hypothetical example. So they protect it and they'll say a chair having a seat, having a backrest, and having at least 4 legs or at least 3 legs. That is what we will write. But then doesn't mean that nobody else can protect a chair. As I told you earlier, a patent is for a problem solution approach. So everybody who wants to do innovations, you always need to know what are the problems and what are the solutions I'm going to give to the problem. So let us look at chair number 2. Is chair number 2 novel? Is it different? Is it new? Yes. Why? It also has a chair, it has a back, it has a seat, it has a backrest, it has 4 legs. But why is it different? Because it's a rocking chair. What's the problem in the first one? In the first chair, it cannot rock. But my grandmother would like to have a rocking chair. So I created this. Oh, you had a chair, but my chair is solving a problem. The problem is I need a chair to rock. And then comes, I have done a rocking chair. So it is novel, it's inventive, and it is capable of industrial application. So remember, even though the chair number 1 was patented, it's a hypothetical example, chair 2 can also be protected because it has a different use and so on. Let me look at example 7 of a chair that has got wheels. So is that, it is also novel, it has a backrest, it has a seat, and it has legs, but it has 4 wheels. Everybody knows wheels. Wheels has existed for thousands of years, but nobody put a wheel to a chair. So if I look at the other examples, what is the problem it's solving? The problem is I have to drag the chair from one place to another. Having a wheels, it is easy to drag it, easy to take it across. I can move very easily, and therefore the problem solution approach is a chair which is easy to move using wheels. Wheels are known, chairs are known, but I was a super person who could now take these wheels, put it on a chair, and therefore this is a good example of coming up, known examples of wheels, known example of a chair, but putting it together, nobody else did it. So it's novel, it has a solution to a problem, and that is why it is patentable. So if I look at example 4 of a chair, that is a folding chair. Yes, because I don't have place in my house and I'd like to have, or in my office, and I would like to have folding chairs so that I can fold it and keep it, and then I can use more space in it. So folding chair, it also has a backrest, it has a seat, it has 4 legs, but it is different from the others and therefore it is novel. What is the problem here? The problem I want is, I want to have less space to stack my chairs, and therefore I've come up with example 4, which is a folding chair. So you can look at different types, they can all be protected by designs, but here I'm talking about a patent which is an innovation. And so listen, even if I have somebody has protected, has a patent for a chair, different examples with different problems and solution to the problem can give me different types of chairs which can all be protected. So take this as an example that I can use it across. So let me give you an example that I can of a wheel. As I told you, wheels were known. I cannot protect a wheel because wheels have been known for thousands of years. People have used wheels in a bullock cart. People have used wheels to, for a wheelbarrow and so on. But how can I apply that wheel to different innovations? So just look at it. I would say wheel has a hub, it has an axle, it has a rim, and it has a plurality of spokes connecting the hub to the rim. So we can have different examples of wheels. As I told you, wheel for a chair, a wheel for a suitcase. People had suitcase, but people put wheels in suitcase. Here is a wheel for a road roller. Why do I do that? Because a simple wheel may not work. This wheel has to actually be used in a road roller. When you make your roads, people will use. So the different types of wheels can also be protected based on what your device is, based on what your product is, and therefore don't think that wheels cannot be protected. Wheels can be protected in different forms: wheels on a chair, wheels on a suitcase, wheels on an automobile, and so on, or wheels on a pottery. Oh, wheels can be used. So then using the wheels to come up with pottery is another example that don't get stuck and say, oh, I need a Nobel Prize invention to protect it. No, you can protect different forms of the invention and how you think of it. The most important advice that I tell students or professors, that I say that you're doing a research, think what the problem is. What is the problem in the art and what solution can I do? So many times when people come to us and say, I want to protect my innovations, we will always ask, what is the problem and what is the solution? So here also is a wheel. The wheel can be used for making pottery. And so think of all the time that you file a patent for the problem and the solution. There can be several solutions for the problem, and each solution can be a patent. Just like I told you about 3M, which is an adhesive, the adhesive didn't work well. I wanted to stick properly so that it doesn't come out, but it would not stick. But then you use that idea, which was a failed idea of an adhesive, to come up with Post-it. And that is the value of protecting patents, because it can create wealth, give you revenue, and it's also exclusive for you. I want to thank all of you all for listening to this presentation, which is an important part of the basics of intellectual property, and I hope you find it useful.